Welcome once again to Lehto's Law. Here's Steve Lehto.
Every now and then a story comes up where we talk about jailhouse snitches. And we also hear about how jailhouse snitches will occasionally get someone convicted who's innocent. And the question is, why are jailhouse snitches even used, at least to the extent that they are? So Bruce sent me a note regarding CBS News and a story they ran out of Texas. A woman named Brittany Holberg, an inmate who's been on Texas death row for 27 years, has had her conviction tossed by a federal appeals court. And just to read between the lines here, for her to be in a federal appeals court on this issue means that she's already exhausted all of her remedies in the state system and lost. So she went all the way through the state system, lost there, had to go to the federal system, and there they said, yeah, the conviction was wrong. So the federal appeals courts tossed the woman's death sentence after it found that local prosecutors failed to reveal that the primary trial witness was a paid informant. So here's the thing. If you're on the jury and somebody gets on the stand and testifies, so that person told me something, would it affect your judgment on that witness if you knew they were being paid by the police or if you knew that they weren't being paid by the police? That being paid by the police thing is actually relevant to a person's bias. So, by the way, the decision was not unanimous. 3 judges, it was 2-1. The U.S. Fifth Circuit Court of Appeals last week sent her murder conviction back down to the trial court, where theoretically they can dismiss the charges or they could retry her but just not use the witness who is paid unless they're willing to disclose that to a jury. And they probably wouldn't want to do that. So she's been on death row for 27 years, and getting her convicted back in 98, prosecutors relied heavily on testimony from a jail inmate who was working as a confidential informant for the city of Amarillo, the police department there. That informant recanted her testimony in 2011, but neither a Texas Court of Criminal Appeals or a federal district court found that prosecutors had violated her constitutional right to a fair trial. The appeals court here disagreed, saying that the informant was critical to the jury's determination of guilt, and the prosecution violated the woman's due process rights by hiding information that should have been disclosed under the Brady doctrine. Writing for the majority, a judge cast the case as a blight on the criminal justice system. Here's a quote: "We pause only to acknowledge that 27 years on death row is a reality, dimming the light that ought to attend proceedings where a life is at stake. A stark reminder that the jurisprudence of capital punishment remains a work in progress." So she was sentenced to death by a jury when she was 23 years old. The jury found her guilty of murdering an 80-year-old man and a former client of hers. At the time, she was a sex worker. During the trial, she asserted that she acted in self-defense. The prosecution, however, presented testimony from her cellmate who alleged that she admitted to killing the man in order to get money and said she would do it all over again for more drugs. And then, of course, later, that witness recanted that and said, I was being paid to testify. And that was never disclosed to the defense. So at the time, the witness was working as a confidential informant for the police department. As a fact, prosecutors never disclosed to the defense. They instead presented the witness to the jury as a disinterested individual who wanted to do the right thing. So the judge writes that the 27 years on death row is a showcase of the state's failure to abide by a core structure of prosecution. That is the Brady doctrine. The Brady doctrine, you've probably heard the phrase kicked around before, is the notion that the people, the prosecution, are required to turn over to the defense the vital information and whatever they're going to use in the case, including stuff that doesn't go their way. And so there's something that would help exonerate the defendant that the prosecution has in their possession. They're supposed to turn it over. And here, the knowledge, the fact that this witness is a paid informant being paid for her testimony, that wasn't disclosed, is a serious problem. And the fact that it took 27 7 years for this to come to light is just absolutely appalling. So in November of 1996, the story says that she had a minor traffic accident and sought refuge in the apartment of the guy who wound up dying. There was an argument that turned violent, and in the end, that man was dead, but she was there and she left, and she also had injuries, though. And so while in jail, the county district attorney's office approached multiple inmates to question them about the defendant, offering them a deal in exchange for testimony. And so when you tell somebody, hey, look, you're in trouble, you might go to jail for a while, if you can get that person to say something incriminating, we might go easy on you. What's amazing is how often someone's told that and they go into the cell with the person and the person says something incriminating. It's the craziest thing. Do you have a record of it? Did you record it? No. Were there any other witnesses? No. So who's the only witness? The paid informant. Oh, funny how that works. So the woman whose testimony was used was placed in the same cell as the defendant, and then she later produced a statement detailing an alleged admission from the defendant. The informant was released on bond. So they basically said, oh, good for you. You did a good job. Now, there was a dissent. A judge here wrote that the jury did not solely rely on the informant's testimony to reach their decision of guilt. And so here's the thing. Was it the sole reason? Who knows? The jury didn't sit down and write a detailed explanation of how much weight they gave to each piece of evidence. The problem is that there was a paid witness that wasn't disclosed. And it sounds like that would be pretty compelling testimony if it came from a disinterested witness who wanted to do the right thing. And of course, it flips it. If it's no, this is a witness who's being paid for her testimony and was released the day after she said she would testify to these things. That's a big motivating factor. Payment and getting out of jail. So they focus on the fact that she's a paid informant, but the fact that she got out of jail the next day is also important. And so one thing I have to tell you, I've mentioned before, obviously I went to law school because I'm a lawyer. I taught law school for 10 years. One of the classes I taught was trial practice. And so if you're going to conduct a trial, you got to know how to do an opening statement and a closing argument and how to do a direct examination, how to do a cross-examination. And when you are cross-examining somebody, you can ask them questions, follow-up questions on what they testified to on direct. And of course, the question is, let's suppose somebody got on the stand and said, my name is Steve Lehto. I saw the accident. The light was red. In other words, the red light that somebody ran. Okay? It's the entire testimony on direct. My name is Steve Lehto. I saw the accident. The light was red that the car went through. How many questions can you ask on cross? A lot of people go, oh, I can ask you about your name because that's what you said. I can ask you about you seeing the accident because you said that too. And I can ask you about the light being red. But then I'm done, right? No. You can always go after foundational issues and things such as bias. So foundational issues are, how do we know how reliable your testimony is? Where were you standing? How light was it outside? Was it day? Was it night? Which way were you facing? Do you wear glasses? Were you wearing glasses at the time? Were you looking at the intersection when the accident occurred, or were you looking that way and you heard a collision and then you turned and looked? These are all important questions that can be asked. And likewise, things that go towards your bias can always be asked. Doesn't matter if somebody brought it up on direct or not. So someone gets on the stand and says, she told me she did it, and she'd do it again. Okay, let's talk about why you are here today. Excuse me, doesn't matter. You can always go after a witness's bias if there's something to go after. Let's talk about the fact that you are a paid informant for the police. The police routinely put you in other people's cells and tell you if you get good information from them, they'll pay you for it. Isn't that true? Oh, yes, that's true. Suddenly the jury's going to perk up. Wait a second, what? How much were you paid? Let's talk about that. They pay you in cash or do they cut you a check? Are you an employee of the police? Are you on their payroll? Oh, they pay you in cash. How many businesses pay people in cash? When you pay someone in cash, I'm looking at the jury. When you pay someone in cash, is that because you're doing stuff above board? Or is that like under the table? Cash under the table. And let's talk about you were in jail on this date speaking to the defendant when you claim she said these things. How much longer were you in jail for? Oh, I got it the next day. They released you the next day. So you go into the jail cell having been told if you get her to say something incriminating, you will get paid and you'll get preferential treatment. Now, she might say, I wasn't told that. Oh, but you were released the next day. Isn't that true? When you're in jail, what's your number one concern? Getting the spending money from the police or getting out of jail? So actually getting out of jail, then again, jury's over here. Again, getting out of jail, but the witness is here. So I can ask a question of you while looking at the jury. So you're in jail and you know that if you get her to say something or you claim she said something, you'll get paid some cash under the table, but also it'll get you out of jail sooner. And quite frankly, getting out of jail sooner is a pretty big concern for a young lady such as yourself. Isn't that true? And go ahead and say no. I don't care. A jury's going to look at that and go, this witness is worthless. So the crazy part is she spent 27 years on death row. Jury convicted her. Appeals court says, good conviction. Apparently the Texas Supreme Court said, good conviction. And then the federal district court, presumably on a habeas corpus motion, said, good conviction. Court of Appeals said, no, bad conviction. And I've seen a lot of cases that went this far. They shouldn't take 27 years. And again, you might say, but Steve, what if there's other evidence pointing to her conviction? Then why did the prosecution use this witness? And you say, well, Steve, it was an oversight. Oh, they just accidentally forgot to give the most important thing they're hanging on to the defense. I'm not saying that I know for a fact that she didn't do it. What I'm saying is she didn't get a fair trial. Believe it or not, the state of Texas screwed up really, really bad here. Because if she did it and they could have gotten a conviction without that jailhouse snitch's testimony, they should have tried to do it that way. And then when they got caught, oops, forgot to give you the damning testimony and evidence that would have helped your client, they should have immediately said, let's give her a new trial. Because here we are 27 years later, and do you think all the evidence and witnesses are still around? There's a good chance that by dragging this out 27 years, they can't retry her. There's a very good chance of that. And by the way, you can't put the woman on the stand because the other woman on the stand because she's now recanted her testimony. So the prosecution could put her on a stand and say, isn't it true back then you testified to this? And on cross-examination, I can get up and say, isn't it true you recanted that testimony and that goes completely against what you said back there? Isn't that true? Yes. Okay. So Bruce, thanks for sending that fascinating story. It's sad because, again, not saying she didn't do it, not saying that all I'm saying is she deserves a fair trial. And that's not that complex of an idea to think about. She deserves a fair trial. That's all I'm saying. So Bruce, thanks for sending that from CBSNews.com. Brittany Holberg, inmate on Texas death row for 27 years, has her conviction tossed by federal appeals court. Questions or comments, put them below. Let's talk to you later. Bye-bye.
Thank you for watching Lehto's Law. Life is a question, and how we live it is our answer.